Coming up to 8:30 here on 93.5, 1430 WCMY. It was last week that the Illinois Supreme Court's decision to overturn a lower court ruling and approve the abolishment of bail in Illinois as constitutional. And this is going to kick in September, if I recall. And we're going to talk about this recent Supreme Court decision, state Supreme Court decision about the elimination of cash bail. Jeff Clayton joins us. He is the executive director of the American Bail Coalition. And Jeff, thank you very much for joining us here this morning. What is the American Bail Coalition? Let's start there.
Sure. We're a trade association of insurance companies who underwrite criminal bail bondsmen and work on bail issues throughout the country.
Well, how do you see this new turn here in Illinois right now?
Well, it's a historic decision. It's against sort of the weight of the other Supreme Courts. But really what it says is that the Illinois legislature can do whatever they want, that there is no right to bail in Illinois, and whatever the Illinois legislature thinks the right to bail is what it's going to be. And in this case, it's going to be no right to bail, and we're going to detain a limited amount of people that we think are the bad people.
And this has never been tried before by any other state in the country, this no cash bail? Didn't California try this once upon a time and it didn't work, did it?
That's a political talking point for Illinois progressives. Of course, this has been tried elsewhere. It's just not been tried like this. Other states that have eliminated bail, like New Jersey, passed a constitutional amendment to eliminate the right to bail by sufficient sureties, and then put into place a system of pretrial supervision funded by the state and a system of detention. So Illinois has kind of done one of those in a limited way, which is there's going to be limited preventative detention when bail is gone, starting in September.
And then how much play does the bench have in deciding whether somebody's released or not? What can a judge do?
The judge can actually do nothing in this case. The prosecutor is going to have to file for detention, go to hearing, and prove the need for detention in order to get it. And this is hugely expensive. That's what costs the New Jersey system a lot of money, because there has to be a mini trial every time somebody's going to go to jail. So this is going to be, one, hugely expensive on the system, and two, it's extremely limited in terms of what charges. And so, repeat felony theft is never going to go to jail in Illinois ever again. So that's what we're talking about. There's some limited exceptions in there for repeat conduct, but on the whole, what we're talking about is sort of a version of New York bail reform that's even more extreme because of the amount of people, the recidivists, that are going to take advantage of this.
How valid is the argument that the requirement for cash bail created an extra penalty on people who didn't have the financial wherewithal to get themselves out?
Well, it's actually a fundamental constitutional right, and what we've seen in systems that move away from bail is that, mass pretrial incarceration increases. So in reality, having a right to bail is better than just having them detain you and throw away the key, because at least there's a possibility that you can get out, that people in the community will feel like you should get out and will post bail for you. So, we've learned throughout the years that while, there's some impact on some, indigent parties, that the right to bail, by and large, is better than a system of detention.
So, I've never been through the experience. So what happens when somebody does get arrested and they've got the opportunity to bail out, but they don't have the financial wherewithal? Is that where a bail bondsman can come into play?
Yeah, in other states we have bail bondsmen. In other states we have personal sureties, which the Illinois Supreme Court basically said you never had in Illinois. It was just cash only, and that was it. So yeah, you have the right to have even these charitable bail funds that have popped up in many states, challenge state power. When the prosecutor overreaches and wrongfully charges somebody, they can go bail you out. That's never going to happen in Illinois. If you're in jail now, they lock you up, they throw away the key. There's nothing else to talk about. You're there, you're not getting out, end of story. The problem is that population is going to be extremely limited in Illinois, which is what's going to cause what I would estimate to be a major crime wave.
So so as soon as these perpetrators are released after they've made a court appearance, then they just walk out the door. essentially.
They do, and that, over time they understand which charges they're going to go in jail on and which ones they're not. And because the bar to preventative detention is so high, they're going to figure it out fairly quickly that there's just going to be a whole swath of charges where there's never going to be a possibility of jail. And if you're talking about criminal deterrence, I mean, if they know that they're never going to end up in jail on some of these charges, they're going to keep committing those crimes in greater numbers.
So they're handed a date, a court appearance date, and a document, and then they may never be seen again, I suppose.
Exactly. And there'll be a list of charges, and there already is, where defendants will know, if I commit this crime, I'm not going to go to jail. And eventually the police are probably not going to arrest people, because why take them to jail if we know they're never going to be there, if we're just going to turn around and release them anyway?
So I would assume the other 49 states are going to be watching Illinois to see how successful this may be.
Yeah, I mean, I think it's very similar to what we saw in New York.
Maybe success isn't the right word.
Well, lack of success, I think, is what people are going to be watching. I can tell you, having talked to legislators in other states, they're concerned about the spillover effect of suspects fleeing Illinois when they finally get caught on that kind of their 10th charge, where they've cycled through the system and now they're really facing the music that they flee to other states. So other states are even looking at what are we going to do about this Illinois problem.
And as you watch this case here in Illinois, we're sort of two states in one. There's Chicago, and then there's everybody else. But we got half the population in the state that's in that northeast corner there. How much of this was driven by Cook County and Chicago in particular?
I think probably all of it. I think that most people in rural areas understand the right to bail, and it makes sense. I think it just kind of stuns me that the right to bail is so fundamental, and the Illinois Supreme Court can just throw it out, and that the Washington Supreme Court, in one of its opinions, can say, of course the Illinois Supreme Court would hold there's a right to bail in Illinois, and they just threw it aside. I mean, it's just a complete disdain for the Constitution.
Well, and we had, I think we had 70-some county sheriffs and state's attorneys who had signed a document saying that, if before the Supreme Court decision hit, that they weren't going to enforce this no cash bail thing. They thought it was crazy, for lack of a better word.
I don't know how this is all going to shake out, but all 69 states' attorneys have opposed this and, went to court to try to stop it. So, the only answer now is the legislature is going to have to do something, and whether there'll be the political will or not, we'll find out. Certainly in New York there wasn't at the time, but then they've now rolled it back 3 times since, realizing it was a complete disaster.
How long do you think it'll take before we can really get a gauge on whether this is working or not?
Well, in New York it only took months, so I suspect by the end of the year, and I think the media will be watching. I think everybody will be watching on this to see how it goes. That we'll have a pretty good idea by the end of the year whether this is going to work or not.
And there's no limit to how many times somebody can be arrested and released? I mean, they'll just go back and do what they usually do and be back before a judge again?
Right, as long as you're not on the list of charges for which detention is eligible, you can commit as many of those as you want. And you'll never go to jail, regardless. And that is the problem. That is not how the system works now. It's, after so many, the judge just isn't going to let somebody out for free or let somebody out at all. And under this scenario, we're just looking at this charge in this case. And if it's bad this time, you stay in. And if it's not, then you never do. And that's going to be the problem.
And that's on any kind of a crime? Even
no, there's some high-level
even murder or what?
It's generally, in the new system, it's going to be crimes F4, felony 4 and higher are generally going to be detention eligible. So some percentage of those the prosecutors will file on. Generally, anything below that's going to get out for free every time. So that's kind of the system that we've created here. And, the legislature is going to tinker with that over years, and there's going to be arguments that this crime should be in and this crime should be out. The bottom line is suspects will get the list. They'll know, and they'll be able to get away with it. And all these quality of life, theft type of crimes, those are never going to go to jail.
Well, this is going to be frustrating to watch, I guess, would be a way to put it.
Oh yeah, absolutely.
I mean, for the average citizen, anyway. I mean, it's just going to be, why is this happening? I guess is the question a lot of people are going to ask.
Right, judges getting it that wrong in the first place. We thought the judges were, particularly in some of the rural areas, were doing a decent job at keeping crime under control in light of a national crime wave.
Right.
But now we're saying the Illinois legislature knows best.
And will it be possible to go back and fix this, but is it going to take legislative action or out of the courts? I mean, the Supreme Court is the final arbiter, supposedly, right? Or could this be turned into a federal case and be taken all the way up?
I don't think so. I think this is a matter of state constitutional law. And I think the way the Illinois Supreme Court has essentially given all the power to the legislature to define bail, to go back in time and say there is a right to money bail, there isn't, all this sort of thing. They've basically said the legislature in Illinois can do whatever it wants. So it's going to take legislation or a referendum, potentially, and I know there's been some talk about that, to fix this.
Is there more about this online at the Bail Coalition website?
Absolutely. Our website, AmericanBailCoalition.org.
Very good. We appreciate the time talking with us today. Jeff Clayton, the Executive Director of the American Bail Coalition, and I guess we'll all just have to wait and see what's going to happen here with no cash bail in Illinois. I haven't had a chance to have our state's attorney and sheriff on yet, but we're going to get to that here very soon.
Well, I'm sure you'll get an earful.
Thank you so much. We appreciate it.
Have a great day.
Thank you. Jeff Clayton, the Executive Director of the American Bail Coalition there. It's 8:40.